of surface waters. I wanted to address provisions 72 and 73, which are the Tier 3 surface water monitoring requirements in the Ag Order and your proposed order. Abby Taylor Silva stated that a grower spent over $8,000 having the sampling and analysis plan and QAP prepared for 2 farms. It's easy to see how this process could be over $5,000 per farm, depending on the farm size. The growers in Tier 3 have larger farms, so because they have larger farms, they have multiple points of discharge from the farms that have to be taken into consideration when the sampling analysis plan and the QAP is written. Actually, the QAP is fairly voluminous but relatively simple compared to the sampling analysis plan, which has to be tweaked for the individual farm. Unfortunately, the order as written and as revised makes it ambiguous how to do this, which drives the cost up because it is unclear how to apply it to each of the farms. And so the consultants end up having to prepare a much more elaborate process than is necessary because of this ambiguity. For example, while it is an improvement to change the word to outfall, some of the language describing an outfall may imply that you're taking a sample that's off the farm on your neighbor's ditch, which would have trespass and access issues. Or in the case of tile drains, it's off the farm in a community sump, and all the water is mixed together from all the different farms at that point. So from the point of view of writing the sampling analysis plan, you have to deal with this vagueness as opposed to simply saying from a discharge point at the edge of the property or the edge of the farm, which would be more succinct and make it easier for someone to divine what is being intended if the regulators come back and say that there was an issue of noncompliance. From the second issue on this is the question of taking a sample that is representative of 80% of the water discharged at that time. Well, it's one thing to know when you're in the field standing there where a representative sample is. It's totally different to write months or years before in a sampling and analysis plan how you're going to determine what is representative of 80% of the discharge at some future date, particularly if it's an irrigation event and you have random places of discharge. It's easy to say that at the time you take the sample it should be representative of the maximum flow, but it's very hard for a grower to determine way in advance what day the maximum flow is going to be on, much less how to do a storm event for the same reason. One of the issues that came up was sampling of ponds, and again this goes to the expense of writing the sampling and analysis plan. There's actually a third use of ponds that is very common on the Central Coast. NRCS has designed and built for many growers retention ponds that are designed just to slow the water down during storm events so that it trickles off the field instead of having a massive surge of sediment off the field. These ponds are designed to collect the water and then slowly release it. Well, if those ponds are sampled as the water, not in the pond, but as the water leaves the property, that makes perfect sense. But to sample the pond also is not necessary because it's just there to slow it down as a slowly leaking dike so that it reduces the sediment. Simplicity would make the cost of achieving the objectives you want to achieve a lot lower for the growers without reducing the information you seek to collect. And it just needs to be tweaked slightly so that it can be applied in the diversity of fields that exist on the Central Coast. And make it easier for whoever is writing the sampling and analysis plans to at least predict or divine what was intended when they write the plans 6, 7, or a year in advance, 6, 7 months or a year in advance. Thank you.
Thank you very much.
You provided that in writing, some example tweaks for us to consider?
I will be happy to send it to you. I didn't submit anything in advance.
Okay.
Okay, next is Karen Burr, Executive Director, California Association of Resource Conservation Districts. Oh, sorry. Sarah, are you still here? There you are. Sarah Amzadeh, California Coastkeeper Alliance.
Good evening. I'll just, I think, be the first to say evening, board members. Sarah Amanzada. Oh, sorry, what was that? Someone already said it?
No, it's not, somebody already said that, but it's really
Okay.
not evening yet, not to be too technical about it.
I realize now that we're on our 6th hour of public comment, so I will keep my remarks very, very brief. I'm representing the California Coastkeeper Alliance, and our Central Coast Water Keepers, Monterey Coastkeeper, and Santa Barbara Channel Keeper presented a very, what I thought, thorough presentation today and have submitted detailed written comments, and I want to support those comments. And I just want to echo something Steve Shimmick said. I truly believe that the frame for this process cannot be what is good for the agriculture industry. And being directly involved in a number of state water board policies and permits, I think we can't use regulated industries' feeling or reaction to these permits and policies as a barometer by which we measure them. And I just urge, I mean, we have some serious issues here. We need to reduce the nutrient discharges. We need to eliminate toxic pesticide discharges. There are serious public health and environmental issues here that are, frankly, starting to make news nationwide, and we simply have to take action to address them. I really call on this board to take leadership role and start to put protections in place now. You know, even as we have an expert panel developing recommendations, even as we collect more science and information, we need to put an effective program in place that protects communities without access to safe water and that stops the spread of contamination. So I thank the board for your work, and I urge you to take swift action. Thank you.
Thank you. Next, Abby Taylor Silver. Now, I just want to say, if those people who spoke during their presentations do public comments now, I don't want you to come back in the rebuttal,
You've got it.
because that's too many bites of the apple, and the day is late, so.
I understand. Thank
Okay.
you. Thank you. I'm Abby Taylor Silva with the Grower Shipper Association of Central California. I want to address a few statements that I didn't find to be completely accurate in today's workshop. So the first, you've heard comments from coast keepers that Tier 1 growers have fewer requirements than they had in the previous waiver. That is untrue. There were a number of new requirements for all growers, including those in Tier 1, one of the most substantial of which is groundwater monitoring. And we weren't planning to speak about our approved groundwater cooperative monitoring program, as this approval was made outside of the timeline of this petition. But since so much has been spoken about it by the Coast Keepers organization, I feel that it's necessary that we correct the record, so I will. Our organization, along with local farm bureaus and Western growers, has created a cooperative groundwater monitoring program that will provide science-based, consistent contour reporting of nitrates in groundwater. I'm personally very proud of this program. It was approved on July 11th, and as I believe it will provide better information that everyone, including the public, and people drinking water that is coming from limited hookups that is not currently monitored by the County Department of Environmental Health, would have received had they just relied on individual monitoring. In our program, you may actually find that there are more wells tested and monitored in certain areas than would have been done in individual monitoring, which is contrary to what you're hearing from the Coast Keepers organization. That's because we're going to be looking for wells that are being sampling our wells in stages and based really on priority. So in stage 1, we're going to look for domestic drinking water supply wells with depth and screened interval information. And we're going to do that so that we can get the most accurate information and data. If we do not get enough from that stage, we're then going to look to wells with depth and screened interval information on non-member parcels of characterization benefit. And the CMP and the water board staff have agreed to work together to gain access and sample these wells. So these could be domestic dwellings that are not enrolled in the irrigated lands program at all. And we'll be working with staff. If they are going to provide a strong characterization of our program and of the area, we will work with staff to go and monitor. And we have made a commitment with regional board staff that says that we are going to work to achieve the highest possible confidence interval. So when you heard from the Coast Keepers organization that we're just not going to sample wells and that you're not going to see all the information you need, that's entirely inaccurate, because what we're going to be doing is looking to achieve the highest confidence interval interval. If there are two wells right next to each other and it's not going to change the confidence interval, then we don't feel like it's a good use of resources to sample another well. We'd rather put those resources into an area that we could get a higher confidence interval. Will there be times when we cannot get a high, close to 90% or more confidence interval? Of course, but if you understand this program, which I believe you do, you know that there are times when there just aren't enough wells, and they would never be sampled regardless because there aren't wells there. So we're going to look to get the highest highest confidence we can based on the number of wells that are available in that area. And I really wanted to make that point clear. Additionally, I wanted to address a comment made earlier by regional board staff regarding nitrate fertilizer recommendations that I believe is inaccurate. You were told that there are nitrogen guidelines available on the Central Coast and that there is a publication that recommends those for broccoli, cauliflower, celery, and lettuce. Chair Marcus asked if there are published ranges for all crops, and the response was that there are published ranges for 90% of the crops grown on the Central Coast. This number seemed inaccurate to me, being that many of my members have told me that there are few fertilizer recommendations available for the more than 150 crops and varieties we have on the coast in our valleys. And I suspect the staff member was referring to the documents produced by Stu Pettygrove, recently a retired UCD soil specialist. UCANR document Nutrient Management Goals and Management Practices for Cool Season Vegetables is mostly a generic list of management practices to consider. Additionally, that could have been referring to the 2003 document, Nutrient Management in Cool Season Vegetables, which contains some more direct nutrient and irrigation info based on some of the work that Richard Smith and Tim Hartz have done in previous years. However, this document, it contains info relevant to nutrient management of some coastal crops, such as lettuce, celery, broccoli, and cauliflower, but it does not give fertilizer recommendations per se, for the simple reason that in the multiple crop year, per year scenario that dominates the Central Coast, field-specific factors such as residual soil nitrate, irrigation nitrate content, weather, the variety being used, and more should be taken into account when determining a fertility plan. Also, these estimates are usually for total uptake and do not provide much information on the nitrate uptake at various stages of the crop development, which would be needed for improving fertilizer management. Additionally, Tim Hartz with UC has told me that UC does not generally give specific fertilizer recommendations for the reasons given above, such as that one lettuce field may require a different amount of fertilizer than another, and the UC system is trying to get out of the mindset that there is a particular fertilizer program that should be implemented in all fields. UC has tried to document the crop and uptake pattern and total and content of the crop at harvest for some coastal crops. And in this regard, we do have a good amount of data for iceberg lettuce, romaine, and strawberries, and we have some data on celery, broccoli, cauliflower, and spinach. However, this list does not include a number of crops we grow on the Central Coast, which is why I knew immediately that that 90% number just didn't sound right. Commodities such as the high-density leafy greens, artichokes, caneberries, asparagus, cabbage, Brussels sprouts, wine grapes, apricots, cherries, peppers, spring mix, and many more are not on this list and represent a great deal of acreage. And so I'm afraid that this
Point
statement...
made. I'm sorry.
I'm sorry.
Yeah, no, your
I
point
keep
is
going.
made.
Okay, thank you very much. I can stop.
Yes, okay,
Thanks.
thanks so much. Sorry to do that.
No, thank you.
Next, we have Delaire Nafusi.
Hello, Madam Chair and board members. My name is Delaire Nafusi. I have been in Monterey County in Salinas for about the past couple months now, and I've had a chance to really observe the progression in the ag waiver as a concerned citizen about water quality. And there are just certain, given my limited experience in this, there are just certain kind of large picture things that I've noticed as the ag industry repeatedly cites problems with them complying with this waiver. And some of the arguments put forth are that it is impossible, they don't have the resources to comply, yet as the regional board has pointed out, 1,300 farmers, I believe was the number, have already complied, as well as the fact that they have the resources to present critical legal analysis at every single step over the past 4 years, ever since the 2004 ag waiver has expired. In contrast that to the disadvantaged community residents like Marta, who has not been able to provide complex legal analysis, and they have repeatedly put forth these ideas that the land values will be destroyed, they will be unable to do business, and these are all conjecture, these are all fears. This is not a country where we allow fears to control us. There's a specific word for that, and I'm not going to mention that, but this is not, we and on the other side of that have brought forth the people affected directly by the actions, okay? If somebody breaks my leg, I have a right to sue them, whether they do it all at once or they do it slowly over years. It doesn't matter. That's the way the legal system works, and it shouldn't matter. We shouldn't grant extra rights to avoid liability, even though it's a concern. If there's a tort committed, if there's negligence involved, if there's repeated, there shouldn't be a veil of secrecy just for this one specific industry. And I feel like that is not being mentioned and brought into the picture, and those are the observations that I've had over the past couple months following this. Now there's a very short. This isn't even the implementation of the ag waiver. The issue here is whether this interim plan will be put into effect. Now, the industry knew since 2004 that when the 5 years expired, there would be a renewal of some sort, and it has been delayed for several years. And even if you ruled that there was no continuance, or prolonging, I'm not sure, I don't want to use the wrong legal term, even if you ruled that it still wouldn't be implemented, it would just be an interim plan to eventually get to that point in which 1,300 farmers have already complied with. Again, the harm is tangible. There are examples. There are people being hurt. The water companies are being sent out. By siding with ag on this, you are at the detriment of the most disadvantaged people, and they are underrepresented. And I just felt like we need more voices to speak out for them. So I support the implementation of the intermediary immediately. Thank you very much for listening.
Thank you very much. Thoughtful. Maria Velasquez from La Voz de San Lucas.
I'll be translating for Maria.
Oh, thank you.
Okay.
Buenas tardes, mi nombre es María Velázquez. Solamente vengo representando la comunidad de San Lucas, de allá del condado de Monterrey, y quiero compartirles lo mala que está el agua. Con nosotros el agua está dañada arriba de 100%, y yo temo por la salud de mis hijos. Tengo 3 infantes y ellos se lavan los dientes todos los días y accidentalmente pasan agua. Y yo tenía 14 pajaritos y les daba agua de botella, y el día que decidí darles agua de la llave, todos amanecieron muertos. Entonces, no hay más residentes de ese pueblo porque todos están dispersos en los campos trabajando, pero yo vine a representarlos, y es terrible la situación. Yo me preocupo por esos niños.
Hello, good afternoon. My name is Maria Velasquez. I'm here representing the community of San Lucas. I should have interrupted. She also wanted to say that she has 3 children, and she's very concerned that as they're brushing their teeth, sometimes they swallow the water, and concerned over what that means over long term. And she was also saying that she has, she had a lot of pet birds, and at one point she used to also feed them bottled water, and within 1 day of switching them to tap water, they all died. And so she's here representing the concerns of the community of San Lucas, most of which are currently working in the fields, and for that reason couldn't be here today. ¿Tiene más que decir?
Es todo, muchas gracias.
And that's all. Thank you very much.
Thank you. Thank you very much for coming here, for staying all day.
I just want to make the point that she left her house at 5 in the morning today and will probably be back at midnight, so.
Muchas gracias. Horacio Amezquita, General Manager, the San Gerardo Cooperative. Hello, sir.
Hi, Chair and board members. I just want to share a little bit of the experience of the San Gerardo Co-op. It's a farm workers cooperative. They built their own homes in 76, 77, and they moved in 79. 1990, they lost their first well because of contamination. In 93, the second one. In 2001, the third one. And then they were put in bottled water for 6 years. And between that period, they had all kinds of problems. They had red skin spots, red eyes, their hair was falling down, and especially on young children and older people. The county, we went and told the county that there was something happening. They sent registered nurses, and the county helped us, and they put a filtration system. As soon as the filtration system was installed, people, all the sicknesses disappeared because they took away the trichloropropane and the nitrates. They were very high, over 100. And so while we were waiting for grants to get a well, it took like 10 years to get those grants. And the only reason San Gerardo qualified because was President Obama created the Recovery Act, and he gave $3 million to that community. And it cost the whole cost of the project was over $6 million. The people, they're happy, but because now they have a good water tap, but it's 2 miles away, and it's costing over $100 or $125 a month. There's some people there that live on $800 from Social Security and disability. So they spend probably 10 to 14% of their income on water. But it's better for them from being evicted because there was a warning that if there was no water, they could have been evicted by not having drinking water. The problem is that they didn't pollute their water under their property, and there was no money to fix it. They had to wait 10 years, and there's so many communities still that have the same problem. And I wonder why California has, it's a huge economy, and still these communities don't have money to get their problem fixed. So I used to be a farmer and a farm worker. I used to farm organically. I used to farm conventionally. I used to harvest the crops. And I understand the farmers. But I think the health of the public and the protection of everyone is very important. And we need to set up a way of finding face the pollution problem that we have. If you have 4 tests a year on nitrates, you will find out exactly what is the pollution all over the Salinas Valley and everywhere. It's only $20 at the county. And any farmer can afford $80, or anybody that has private wells. So I just suggest that it's better to face the truth. It's better to have the true numbers of contamination that is happening. Don't allow this to keep going. Contamination is growing. We need to face it. And it's better for the good of the children of farmers and the children of anybody. A lot of people are not farmers, a lot of people are farmers. But the future of California is going to depend on clean water. So we need to face it. Thank you.
Thank you very much. Kenia Acevedo, Staff Attorney, California Rural Legal Assistance. My apologies if I didn't pronounce your first name right.
That's okay.
I know I should remember.
It's Kenya Acevedo. Good evening, Madam Chair and members of the board. So, staff of the Central Coast Regional Water Board have taken several years to develop the conditional waiver of waste discharge requirements for irrigated lands. This process, which originally began in 2008, has included lengthy and thorough public discussions and public involvement. And throughout the process, agricultural pollution of groundwater that affects drinking water has been of paramount importance. Rather than convert the hard targets that are established in the order through this long and arduous process and extensive public comments over the course of the last few years into converting them into soft milestones, as in the case in Section 33 and Provision 82, the State Board should adhere to the firm, measurable requirements and standards that are consistent with the Basin Plan and the anti-degradation policy. The considerations that go into an analysis for anti-degradation, I think, are useful to this board. Considering the maximum benefit to the people of the state, the effect of present and future beneficial uses, assuring that water quality changes do not drop below state policy standards, and utilizing the best practical treatment and control methods available are very important and help and while adhering to the law, strengthen the order rather than diminish it. They do so by providing clear and articulable considerations that balance the various needs, including the urgent need to address the widespread and increasing problem of nitrate contamination. So let me give you an example. Earlier, Member Moore indicated his concern for changing the terms of Provision 33 to indicate a reduction rather than avoiding the release of contaminants. And I think utilizing the standards of the anti-degradation policy, which delineate the importance of best management practices, and imposing that will help frame the wording of Provision 33, as well as dictate whatever enumerated options there are for farmers to adhere to. So I think in that sense, utilizing and adhering to the law with regards to the anti-degradation policy can help strengthen the order significantly and provide guideposts for the State Board to use. Secondly, I'd like to state that I agree with the regional board's suggestion that the use of an expert panel should focus on the next iteration of the ag waiver, and that it not delay the process of implementation. The imposition of an interim process, as is proposed today, is necessary given that the needs of disadvantaged communities and private well owners that suffer from contaminated water today, those effects will not go away and need to be addressed immediately. Lastly, I'd like to clarify some statements regarding the cooperative monitoring program that was approved by the Regional Water Board. Specifically, I'd like to point to two very important facts. First of all, with regards to contour mapping, it was stated that there is an effort to produce the highest confidence interval. While that may sound promising and informative, there is a great concern that that confidence interval will not be at a sufficient standard for to guarantee that the safety or to guarantee the accuracy of the information. For example, or just to clarify, part of the discussions with in approving the proposal were that they provide 95% confidence interval. It was indicated that that is not possible given the amount of wells in the area, which leads to the conclusion that that the confidence intervals provided will automatically be below 95%, and there is no indicator or baseline for that. So that is very problematic because people would be relying on that information provided in a public internet, through the internet, and in that sense it could be very misleading. And secondly, even if that information, which already has its problems, it's not going to be produced to the public until the year 2015. And so those delays and difficulties with providing access to information to the public are very problematic. And I guess I'll close by saying that for decades we've recognized the extent of nitrate contamination, and we've recognized the extent to which it affects human health. And I think it's very important that we put protections in place now and not delay them any further. Thank you.
Thank you very much. Dale, where are you? What? He had to leave. Oh, he had to leave. All right, and then the next I have a Phoebe Seaton, and Phoebe's card says it's EJ rebuttal, so I'm going to save it for rebuttal. Okay, great. We're going to move to rebuttal then. That concludes our public comments. Thank you all very much. That's very, it is always helpful. Okay. First will be the environmental petitioners. 5 minutes.
Good evening, and my name is Steve Shimmick, and I'll be doing the rebuttal for the environmental petitioners. First of all, thank you so much for hanging with us. This is hard. It just is. So I'm going to kind of go point by point on the things that and this will be fairly direct rebuttal, kind of. So I hope that that's what you're looking for.
No, that's his for.
First of all, there was a great deal of talk in one of the presentations about the timing of these pesticide applications and how important that is. There's nothing in this order that prescribes the timing of not pesticide, but the fertilizer applications. So that just isn't relevant. There was also the idea of shutting down the tile drains. There is nothing in the order that suggests that tile drains need to be shut down. These tile drains do need to be monitored. I think that that's incredibly important because we need to understand these discharges so much better. And so we are not trying to shut down the tile drains. We are trying to understand the tile drains and monitor them. There, in that same comment, there was a comment about, well, we discharge to ditches, we don't discharge to state waters. I would suggest to you that those ditches are state waters in many cases. And I would also suggest to you that sometimes the ditches are ditches that used to be state waters and creeks. Again, we heard this argument of, you know, it says that we must comply. This has been dealt with over and over and over again, and I will spend no more time on it than that. There's nothing that complying today is any suggestion. There was this cost of the QUAP, $8,000 to $10,000. I've done a QUAP, and we used a template, and it didn't take that long. It just didn't. And the regional board has made it very clear that they expect these templates to be used, and they are not expecting a custom QUAP for every single farm. So, you know, I'm sorry, it just isn't going to cost that much. There was also a comment about, you know, that the regional board is going to target those people for enforcement that are pumping and fertilizing and using high nitrate in the irrigation water. I can't recall anything in the order that says anything like that. Maybe they can say that, but we want people to pump that water that has high nitrates, and then we want them to balance, do some nutrient balancing so that they use some of that nitrate up. There was a suggestion that these third-party coalitions would be useful for measuring good faith efforts. I don't think that that's a good way. That's the fox guarding the hen house. And then same thing with groundwater only for public safety. We must also do groundwater not only the household, but we also must characterize the aquifers and do the other work that is important too. There was a suggestion made by, or not a suggestion, but a comment made by Mr. Moore that, that monitoring is not compliance. I agree. However, reporting facilitates compliance. When a person has to show their work and then has to improve upon their work in the years to come, that fosters compliance. So that would be my point. We heard that from CDFA that no one can meet a 1.0, and I might agree, except for the fact that within the order it asks people to report what their crops need, and it's not really that measured thing of right. You know, how much that crop actually uses. Plus, there is slop in that. In other words, you could hear from the regional board that they also are not accounting for material that's tilled in. And they can go into more detail on that. I will finish up by saying simply that we need to have a strong order in place now, because this process is going to drag on. So don't think about, oh, we'll gather more information and add it. We need a strong order now. Drinking water is the highest use of water. Let's keep that in mind. Irrigation water is the second highest use, but drinking water is the highest use, beneficial use, as declared by law. We must protect it. And I want to clarify, I did not mean to say that we don't need those other numbers of, so I agree with Jennifer Clary that we need that full set of reporting numbers, which includes the amount of nitrate in the water, the nitrate in the soil, and the nitrate product being applied, as well as the amount being used by the crop. We need that whole set. And I think what was interesting was the Central Valley gentleman actually said, you know, boy, these are important numbers. And again, I don't want to undermine my own petition, but I do want to suggest to you that what is important is that we need those numbers. We need that information so that we can move ahead. And that the reporting of those numbers is critical, and gutting or suggesting that we don't need those numbers is just not. And finally, I just want to end by how important it is to monitor those ponds. There was the point that some of these ponds are ephemeral. The vast majority of the ponds are not ephemeral ponds. They are, in other words, that they're used to, you know, capture stormwater and capture the sediment. That's good. But there are, I mean, I could fly you someday. Perhaps you don't want to fly with me. I would suggest to you that as you fly over the Salinas Valley, it glistens with ponds. Thank you.
Thank you.
Just for the record, I said reporting does not equal protection. Okay. I mean, reporting does equal compliance in many cases. Just want to be clear. Thanks.
Who's speaking for ag? Okay.
Mine will be very short. I will then to Bill. Everything Steve said, opposite. I'm done. No, just a
Did you
couple of real
notice that
quick.
he left that glass of toxic liquid?
You know what? I was going to get up here and
Who
say
wrote
I'm
that?
thirsty and pour it and have a sip just to see what reaction I got.
I actually
but,
didn't
he
say
took it
anything
away.
about it because I was waiting to see if anybody would say anything about it. You moved it? Oh, yeah. That's true.
Tess Denham on behalf of Grower Shipper. I want to make one point I think it's important for the board to understand. There's been a lot of discussion about the recently approved cooperative groundwater monitoring program, and I think it's important to note that was approved very recently. It's not at issue before the board, and I would hope that the board is not looking to opine on that and that it hasn't been fully briefed. I have a feeling you will see its approval before you, perhaps, but that is not an issue, so I just want to make sure we're careful about that. The other issue is, I just want to say, you know, for all the reasons stated, don't add back in the provisions with respect to nitrogen ratio reporting. For all the reasons, it's a management tool, and it's, you know, allow the expert panel to do its job. Don't increase the reporting requirements as requested by some as compared to where they currently are as proposed in the draft order. We think that there's plenty of reporting as it is, and adding in some additional ones, which has been suggested by some others, we don't think it provides any additional information. And please clarify and make sure that if the waiver is abundantly clear that compliance is the iterative process, because I don't think that the waiver is clear in that regard.
Bill Thomas for Ocean Mist RC Farms. Just a couple of comments. We too think this order needs to be settled and put in place and move forward. We think that your board in your draft improved it immensely and should accordingly move forward. There's been a lot of comments made to kind of throw stones at it. I wanted to just remind us all a few things that are in it. It requires groundwater monitoring on both domestic wells and ag wells. We're on the threshold of getting more data on groundwater than has ever been gotten anywhere else in this nation, because this is the only place that non-point source ag water is regulated. It's not regulated under the Clean Water Act. You know, we are on the cutting edge here. The order also in the compliance form requires the reporting of the nitrogen you used, as well as the nitrogen that is in the soil and in the water. It thus gets you everything that Mr. Shimmick's chart showed, but for the enforcement component that had been written in this order on the ratio that you wisely took out in your stay. That's going to now be the turf of the expert panel to say, is ratio appropriate and how? Is rate better than ratio? Is nitrogen hazard index? Or maybe they'll come up with something different. But the data is coming in under how you've written the order. It's just the enforcement component that is yet to be written, or a system that would lead towards that. Thank you so much for a long day.
Thank you very much for hanging in there with us. Central Coast Water Board. I'm going to let the EJ petitioners be last because they spoke last, and give them a little break. Be able to, unless you feel that you should be last. I'll see if they're willing, but I'm okay.
Good evening. It's been a long time. Thank you for hanging in there with the rest of us. So I'm going to go through a few specific rebuttals, and then I'll leave it to Francis and Michael Thomas to wrap up. So again, Angela Schroeder from the Regional Board. So the first thing I wanted to mention was regarding the groundwater pollution hazard index that was developed by the expert panel after the 1988 report, and I understand the CDFA was also involved. This requirement was actually inserted in response to comments from ag reps. So after our 2010 draft, where we had our Central Coast Water Board version, they asked us to include the groundwater pollution hazard index, and we agreed to do that. And in fact, the December 2010 ag proposal, which I believe Carrie Fisher was involved in, actually included that pollution hazard index as well. So it's confusing to me as to why we're trying to take it out now. I also wanted to clarify regarding the crop nutrient guidelines. So I think what is being characterized as my statement is somewhat inaccurate. What I said was 90% of the acreage. So again, Monica Barcarte was in charge of developing these irrigation nutrient management, and at one point in time, the nutrient balance ratios were a compliance point. So before we did that, we underwent the detailed evaluation to understand how would that affect the high-risk crop types on the Central Coast. However, I do also want to point out that the requirement is to report, the grower gets to report what the crop needs are. They don't have to use a published guideline. Certainly, we've heard a lot about precision agriculture and the art of farming, and growers are not willy-nilly applying fertilizer. We know that. So the point is, let's try to understand what the basis is for those crop needs. Containment structures, we actually evaluated whether or not there was a lot of reuse going on. It was actually a question in our annual compliance form that was stayed, so we weren't able to fully evaluate that, but we agree with Mr. Shimmick that it's not a widespread use. Groundwater monitoring, I want to strongly disagree with the changes proposed by ag. As Ms. Clary described, the previous order did not require any groundwater monitoring. And the first version of this order required more extensive groundwater monitoring. The current monitoring that we have in place is a compromise. We said rather than install new wells or new monitoring points, we would use the existing ones, the existing drinking water wells and irrigation wells at a lower cost. And certainly, we also know that the cost of conducting a nitrate sample, as Mr. Horacio Amasquita mentioned, is very inexpensive and very low compared to the cost of bottled water, for example. I also wanted to talk about the characterization of the use of fertilizers. So Ms. Dunham mentioned that we had inaccurately characterized the use of fertilizers. And the use of excessive fertilizers is well documented to be a cause of nitrate impacts. And the situations described in the staff report are the result of information from grant projects, as well as technical information submitted by growers to the Water Board. As part of our record, I want to point out that in Administrative Record number 329, we actually produced a nutrient budget that was submitted by a grower, and the purpose wasn't to show his example, but to show the example of a spreadsheet. However, it's worth noting that in this particular case, the grower self-reported applying more than 3 times his reported crop need. I also want to note that we did not conduct enforcement in this case. What we told the grower was we need to improve practices and for him to submit information on how he was doing that. And that's sort of the norm for what we do. I also want to clarify that this information about nutrient, nitrogen budgeting and nutrient crop uptake values is clearly trade secret. And so it's protected from public disclosure. So comments about liability or the fear of that being released in a PRA request really is not founded because it is protected. And did I forget anything, Francis? You're going to mention some legal issues.
That's good.
I was just asked if we have just maybe 2 more minutes. I was going to say something. Michael was just going to close.
Yeah.
So, okay. So I just want to say on the there seems to be some confusion about provision 10 and provision 11. Provision 11 was the so-called Michael Johnston proposal, which basically was about if you're a group and you want to propose a group project, a management practice project, or a group, cooperative monitoring and reporting program, you would propose that to the regional board, and then there would be a technical advisory committee to assist the regional board in reviewing that. The draft order before you proposes some criteria for evaluating those projects and those monitoring and reporting programs. That's what that's about. And there's a proposal to change that to say water quality management programs, and that isn't what it's about. Water quality management program, I'm not quite sure what that is supposed to mean, but this was specifically about projects and cooperative monitoring programs. In provision 10, a coalition group is free to propose a program, and as you've heard, the agricultural group did and the regional board didn't approve that program, but there's nothing to stop that from being submitted again. And just to point out that in Region 5 there have been coalition groups for many, many years, and as Mr. Schmidt pointed out today, there is not a coalition group in Region 3. So Region 5 and Region 3 are very different in that respect. There's many, many more dischargers in Region 5 than Region 3, and the coalition groups began more than 10 years ago, so there's a big difference between them. Anyway, then Michael was just going to close.
Thank you. I just wanted to say that Mr. Clausen said that the balance ratios are not a regulatory endpoint, and we agree they are not.
That was going to ask you that question.
And we do not use them as such. Mr. Thomas said, Bill Thomas said that the ratios are not an enforcement component or should not be, and your draft order changed the Central Coast Water Board's order so that the ratios are no longer an enforcement component. They were not an enforcement component in our order. And Ms. Dunham referred to our regulatory hammer when talking about these nutrient numbers and reporting them to the water board. And as Angela pointed out in one example, where a farmer reported to us that his ratio was 3 times what the suggested amount was. That suggested range was 3 times the range. So what we did was we talked to him about that. And he changed his practices and brought that ratio within the parameters, the recommended parameters. That's what happened. And that's what happens. We can't take enforcement action on a ratio. The order, as we wrote it and as the board adopted, wasn't set up to do that. And we're not suggesting that you make it enforceable. It's just information. It's used to help improve practices. And that's what's going on a day-to-day basis right now, because growers are implementing this order that the regional board adopted. And they're making progress, and they're often making progress based on the information that they are generating and reporting to the board, including the reporting of groundwater data. I just wanted to end with that. I wish that you could actually see it happening. I wish you could see our staff talking to and meeting with growers every single day. They probably have thousands of points of contact since that order was adopted. And they're doing a good job, and the growers are doing a good job. It's working. Thank you.
Right. Thank you very much. Ms. Seaton, you get the last word. I mean, other than us, of course.
And there was no one left to call.
And then there was no one left to call.
Phoebe Seaton, Leadership Council for Justice and Accountability, on behalf of the EGA groups. Just a couple of things to note. First of all, the I think suggestions to wait for the order to be implemented in full, for the expert panel to be to come out with their suggestions seems like little less than an effort to further delay this, and we don't support that at all. As everybody here has mentioned, this is an iterative process. We're going to continue to develop stronger and stronger and better orders that serve the needs of all of us, and the expert panel will help that process go forward. In terms of use of nitrate, just to reiterate what the Central Board said. The nitrate report illustrated that nitrogen use exceeded necessary nitrogen use, so people were applying more than they had to. If in fact nitrogen use is exactly in line with what's necessary and appropriate for crops, then we wouldn't be in the situation we're in. And I think that these orders just provide that extra push to get us closer and closer to where we need to be. In terms of reporting and monitoring, we need to be using the information that we have. We need to be collecting both ratios and applications so that we can, for an effective and cost-effective program, we can use that data to again, get closer and closer to the targets. And I want to note that we do not see, and I think others will join us, that the East San Joaquin Rivershed order is not a model to be followed. We have major issues, and we filed a petition in response to that order based on both monitoring and failure to achieve anti-degradation standards. Finally, and this might not be the time, but we definitely want to rebut the grower and shippers motion to strike with respect to our comments regarding anti-degradation and the human right to water. Whether or not the board considers those comments as part of its deliberations, right now the law of the land is anti-deg as announced by AGUA and the human right to water, and therefore those analyses must be considered in whatever order you come up with. And I think that's it.
Right. Thank you very, very much. Well, thank you all for your attention and your comments, and I can't tell you how helpful they are, and sitting here this long is incredibly helpful and puts us in good position to take our next step. We are going, before we go to break and let you all go home, because we aren't going to be making a decision today that we would be announcing. We do have a motion, but before I turn to Mr. Howard for the motion that we need to take up, I just wanted to know if anybody wanted to say anything. Give you the opportunity. Not necessarily you, Mr. Howard, yet, but the board members, if there was anything they wanted to say before we moved on to the next issue.
I think there's something they want us to say.
I'm sorry, we couldn't quite hear what you were saying up on the dais, but are you planning on moving now to the next item on the agenda?
I was just giving my colleagues just if there's anything else they wanted to say to the group, even though we talked a lot in asking our questions. So I'll just say thank you for the time. I think we're very mindful of the fact that protecting drinking water and surface water quality is our prime objective. Not unnecessarily hurting ag is obviously a part of that as well, but I think for the framing question, I think it's quite clear that our mission and objective is to protect water quality, but we're supposed to do it in the most thoughtful way possible, and that's what we're trying to do. And I guarantee you we'll be taking all of your written comments as well as the very thoughtful, I thought very thoughtfully presented comments all around today. It was just very helpful on a number of particular issues, and we'll be following up on it. So thank you all very, very much for the time and actually the selective care with which you made your oral comments. That doesn't always happen, and I appreciate that, as well as the public comments. So I found them very helpful. So now, moving on to item number 12, unless there's something Mr. Wiles would like to say first. If it's amusing, you can definitely say it.
It is definitely not amusing.
All right, well, you can say it anyway.
No, I was just a little bit concerned by an earlier statement that people be advised that at this point the comment period is closed. We're not expecting any further comments, as Mel explained. When we do put out another revised draft, we will entertain comments, but those will be just comments focused on the revisions in the next draft and not on anything else that we're not changing.
All right. What I would suggest then, because as I recall the question, it was in answer to a question, and that is a question doesn't necessarily have anything to do with this ag waiver. So I will just ask the asker of the question to talk to you about how to get, it's like public record information that they were asking for, just so you know. But no more comments, you're right, until we put out our next draft. But the board can ask for whatever information it wants from wherever, as long as it's not a comment on the waiver itself.
I think I'm following you, and actually, I'm not sure I am
The
following
question
you.
was actually about a different waiver.
Oh, okay, yeah.
Yeah, about a different permit. It was about the substance of something as opposed to a comment made here. So, but you're right to raise that point. I thought about it when it was said. Now, take it away, Mr. Howard.
Item number 12, unfortunately, the board exceeded the 270 days allowed under regulation for us to act on this petition. Oh, maybe not. But we might be exceeding it, and so this is a motion to, for the board to take this up on its own motion to hear this item if we exceed the 270 days.
I have comments on this. Oh, interesting. Okay. Fine.
People presenting, but I doubt if they really have anything further to say besides what I said, so you might want to go to your cards.
I don't think we have anything to add unless you wanted us to go through the explanation again, but
No, I
we
thought,
kind of
I think the two
went-
people who'd be commenting actually were here when you did the explanation at the beginning of the day. So I think we're all right there. Do you- anything
Actually,
you
there,
want to
there
add?
was one staff proposed change in response to written comments that may help the commenters before they speak.
Oh, then go ahead.
So I would suggest to Ms. Wadwani go ahead and read that.
Okay. I was going to introduce that at the end if needed, but here was our proposed language to be added as the last sentence prior to the section that reads order. It is hereby ordered. This would be the last sentence at the end of the last paragraph. We will add, consistent with its stated intent in Order Water Quality 2012-0012, which states certain provisions of the agricultural order. The State Water Board remains committed to adopting a final order resolving the petitions no later than October 1, 2013.
Okay. Thank you. I'll go to the speaker cards then, if there are no questions. Mr. Schimmick.
This is Steve Schimmick, and that was my request of that there be a end point time certain, and I appreciate that revision, so thank you so very much. Thank you.
Good suggestion. Ms. Fisher. You're all talked out. Okay. Thank you very much. Is someone question or something say? I just want to say one thing. We are endeavoring to do this as we understand the speed issue. What? Closer. Thank you. That was good, nonverbal communication. Yeah, actually, the way you do this, that means volume. That's right. So, we do need the time to be thoughtful, and the extra time we're spending both reading things, listening to people, and then being able to go out for another period of comment on our next revision, I just think will help us get the best possible action, and we will try and endeavor to do it as quickly as we can. So, with that, is there a motion?
So moved as amended, and I would reference an order number, but I'm not quite seeing it on the draft here. Order WQ 2013, but it just has a dash.
Order
not
number for this, the proposed order, motion order, it hasn't been assigned one
Yeah.
yet.
Oh, okay.
So you can just reference it as the subject order.
Second.
Any discussion? All right, all in favor?
Aye.
Aye.
Okay, the motion is approved. As I said before, we are moving to closed session, and we won't be coming back because we're not going to be making any decisions today. I want to do something. I have no idea if this is if we've ever done this, if there's a policy or how to do it to correct me, but I wanted to adjourn in honor of someone, which I'm sure Fran will agree to, and many of you will, which I just want to adjourn in honor of Lillian Kawasaki, who passed away not very long ago. She was a longtime water leader in Southern California, and it's hard to let, am I not supposed to do this? It's hard to let a meeting go by without mentioning her, because she's been such a leader across the West.
No, and I think that's absolutely fine. However, the adjournment is premature because we have to come back to adjourn after closed session.
Oh, even though we're not going to
Yeah, even though there's not going to be an announcement.
Okay, well, thank you.
But it's
But
good
at
to
least
get it
I
out there
said
now
all
where they
these
can hear it.
people were here. That's true. I mean, for those of you who knew, she worked first environmental affairs director in Los Angeles, worked DWP and head of the community development department, but also then spent probably before her retirement, but her retirement as a member of the Water Replenishment District Board and also in leadership across the entire western states in water, particularly women in water, but in a way that was just inexhaustible and phenomenal. So I just couldn't leave without saying something about it.
And we'll make sure the minutes reflect that when the board ultimately adjourns.
Okay. Thank you very much, Counselor, for saving me there. All right, we will recess.
Thanks, everyone.
Thank you.
Thank you. No, I didn't fly. The coast was fogged in. Yeah. Plus the reality is that there is an adage in private pilot flying that if you have to get there, drive.
So now No, I flew for a while too before I had kids, and
Yeah.
I just thought, oh yeah, I can use this on this and it was like 0 times because exactly that reason.
Right, right.
And there's the other one, if you don't go too far, the commercial's still better.
Yeah. So actually, my rule is that I actually pre-flight and get ready to go, still with time to drive.